Hello friends, good afternoon and welcome to EduSet Live Lectures. Dear friends, today in Political Science we will be continuing with the previous discussion on constitutionalism and democracy. It will be part 2 of the same discussion. In discussion we will be majorly focusing on India, and we will also try to see as to how with evolution of democracy the relationship between constitutionalism and democracy is intensifying. With this regard, we would like to welcome Dr. Satish Kumar Jha on our show to discuss this topic. Dr. Jha is Associate Professor in Department of Political Science in Aryabhatta College, University of Delhi. He has over 25 years of teaching experience, and he is an expert in the fields of political theory and Indian political thought. Without further ado, I would like to welcome sir to our studios and request him to start the lecture. Welcome, sir.
Thank you, Amrit. Good afternoon. In fact, today's lecture is a part of the two parts discussion on constitutionalism and democracy. The first part of this two part series on this theme was delivered last time. What I will be doing in today's discussion is to focus on how this idea of constitutionalism and democracy both have evolved and have taken different forms with the passage of time and with its movement from one geographical region to another. So therefore, what we find that there has been a very intense interaction between three factors: time, geography and ideas, so far as this evolution of constitutionalism and democracy is concerned. The way constitutionalism has evolved, and we have had discussion about this in our last lecture, that how it has evolved over the ages, starting with the ancient period, both in the Greek Roman tradition as well as certain Eastern traditions like India and so on and so forth. The fact of the matter is that this evolution reached its pinnacle in modern period, particularly in 17th and 18th century in Europe, due to a number of factors. But most important factor, of course, was enlightenment and the development of individualism, liberalism and socio-economic system based on capitalism. So therefore, this entire process of evolution of democracy and constitutionalism reached a very definitive stage in modern period of time, particularly in Europe. So much so that many scholars, political theorists of democracy like C.B. Macpherson argues that in fact liberal democracy is a modern phenomenon. It has started only with the market society of the West. So therefore, when we talk of liberal democracy, we have to confine ourselves to the discussion of modern period, that is 17th and 18th century Europe. But the fact of the matter is that maybe the liberal concept of liberal democracy may be new development, new addition in human history, but human minds were engaging with this question of empowering people, will of the people, the power of the people to make changes, or in other words, one can say that how sovereignty is a prerogative of human beings. And therefore, this issue is not new. In fact, as we had seen in our last discussion, that how the Athenian democracy was debated and discussed, how a powerful critique emerged, and particularly as I mentioned earlier in my last lecture, that Plato and Aristotle, the two Greek thinkers, both of them had a strong reservation on democracy. In fact, Plato wanted to checkmate it, rather transcend it through altogether different mechanism, and this is how he envisioned a rule of a philosopher in his ideal republic. On the other hand, Aristotle took altogether different position on this issue, and therefore I also mentioned that how Aristotle's position came very close to what Plato later on modified his view in his book Laws. But Aristotle, in fact, who is considered as father of political science, for many contributions he made, and some of the contributions are still relevant and used in political science, including his classification of government, and how Aristotle argued that government by law is basically the best way to govern human society, and how he talked about that government by law. And therefore, he not only deviated from Plato, but also set a new tradition. And as I mentioned in my last lecture, that how he did a classification of government, he studied 158 constitution, and then tried to evolve a system based on the combination of democracy and aristocracy, and therefore a golden mean he tried to evolve through his ideas, whereby the best of the two systems could be combined and a better system of government could be put in place. But what is interesting here, that both the democracy as an important idea, as well as constitutionalism as a kind of constitutionalism in order to checkmate the raw power of the people, this issue is not new in social science, in political science, and in evolution of ideas. Scholars have been, thinkers have been grappling with this issue, and therefore the best example is the Greek tradition, because as I mentioned earlier also, that democracy ultimately implies the will of the people, the raw power of the people, whereas the constitutionalism implies a limitation on that raw power, or one can say a limited concept of limited government. And in modern times, this conflict, this tension has surfaced off and on, and there have accordingly have been many churnings on this issue. In fact, the best example in terms of thought and theory could be Locke and Rousseau. How Locke talked about limited government, whereas Rousseau talked of sovereignty of the people, or will of the people. So therefore, the combination of two, the Locke and Rousseau, perhaps has been attempted through many applications and implementation over the years and over the ages. And therefore, when I talked of in my last lecture 4 model of this constitutionalism, it was essentially based on this. In fact, modern constitutionalism, as I mentioned, that one can see in terms of 4 or 5 different models, where attempts have been made to combine the two things, that how the raw power of people can be checkmated, how a concept of limited government is in interest of the people, and therefore constitutionalism has been considered a very important instrument through which democratic experiments or democratic societies can be governed in a better way. So therefore, on the one hand, the importance of democracy, no one can basically dispute that, it cannot be diluted. On the other hand, importance of the limited government. So how these two things can be combined, and therefore if you look at the evolution of this the two things, the constitutionalism and democracy, we can figure out 4 or 5 models. The first model is Anglo-Saxon model, particularly prevalent in Britain and United States of America. 2 classical cases, both in terms of constitutionalism and democracy. So that is the Anglo-Saxon, the model emerging from the Anglo-Saxon world. The second is the continental European model. Here, of course, one can refer to the French model, the German model, but most importantly, Swiss model, a surviving democracy, a very important example of a federal democratic polity with many new innovations. So therefore, the continental European model is different from the Anglo-Saxon, particularly the British and the American. And then the third model I mentioned was the Commonwealth model, which is basically prevalent and available in Commonwealth countries like Canada, Australia, New Zealand, India, and so on and so forth. These countries were colonies of Britain or some imperial power, but particularly Britain here, and their evolution of constitutionalism and the development of democracy and democratic process in these countries has taken altogether a different pattern, and therefore Commonwealth countries and the model which is available there is also generating lot of interest among the scholars of constitutionalism and democracy. When we talk of constitutional Commonwealth model, then of course there are many variations among these countries, but nonetheless there are some commonality, and the most important commonality is in terms of combination of parliamentary and federal features of Britain and United States of America. Of course, many of these Commonwealth countries and their constitution started evolving with their relationship with Britain, but nonetheless many of these countries have also adopted the federal features of the American type. So, therefore, this combination is interesting, and within that combination one can say many variation, particularly in India, which will basically take up toward the end of our discussion, that how India offers altogether different model of constitutionalism and democracy. Then of course, there is another model, that is the socialist model of the socialist countries, and what is that socialist model is also interesting, because erstwhile Soviet Union and China, today's China, both have been talking about a socialist constitutionalism. What is the socialist constitutionalism? In fact, in my last lecture I had mentioned that Thomas Paine had observed regarding Britain that Britain had a constitutionalism but no constitution. Rather, he called it a democratic polity, not a constitutional government or constitutional rule, because Britain does not have a written constitution, and according to Paine, written constitution is one of the prerogative, one of the prerequisite of constitutionalism. But on the other hand, when it comes to socialist countries, one can say that these socialist countries had constitution but no constitutionalism. If Britain had constitutionalism, no constitution in opinion of Paine, then these socialist countries had constitution but no constitutionalism. They had a written constitution, but in fact some of the features of constitutionalism, modern constitutionalism, which are which is understood in terms of rule of law, multi-party democracy, independent judiciary, and and so on and so forth, these things were totally absent. So therefore, the socialist model is also interesting to observe. And finally, the third world model of constitutionalism. In fact, when I talk of third world model, I am making distinction between the Commonwealth model and the third world model, because third world model is characterized by a very transient, or one can say a temporary phenomenon of democratic government and constitutionalism. There are many countries in Asia, Africa and Latin America which at times come under democratic rule, but immediately that is superseded by a military dictatorship. Some of these countries draft constitution, try to enforce it, but sometimes they fail. Even in India's neighborhood, one can say that Pakistan, Bangladesh and many other countries, they have been passing through this process. Off and on they have democratic governments, but then again those governments basically collapse, and that they are followed by a dictatorial or military rule. Similarly, there are many other countries in Africa and Latin America where you have many types of turmoil, and due to which constitutionalism and democracy do not become very stable experiment. Of course, Latin America is little bit different because Latin America, the evolution of the state power, the nation state is also different. In fact, I mentioned in my last lecture that how consolidation or national unity contributed also significantly in direction of this concretization of the idea of constitutionalism, because with the emergence of nation state, particularly after Treaty of Westphalia 1648, when the nation state started crystallizing in Europe and a national unification took place, that resulted into increase in the power of the government and the state, and therefore there was a threat emanating from that source, that is a strong state, and therefore a concept of limited government was necessitated. And it is here one can mention that how in Britain James I, when he basically invoked this idea of divine right of the king to rule, and how that generated a reaction in form of social contract theory, which in hands of Locke became the concept of limited government. So therefore, consolidation of nation state, unification of territories, and therefore rise of a powerful state also contributed in direction of this constitutionalism as a limited government. So therefore, what we find that the two models normally associated with the state formation, the Westphalian model of 1648, particularly Treaty of Westphalia, but that was characterized by a strong sovereign nation state, a unified monastic concept of sovereignty, and that model was basically questioned only by the emergence of another model of the nation state, that is divided sovereignty and the shared power and shared authority, and that concept is best represented by the theory of federalism, which emerged in the United States of America, particularly after American War of Independence in 1775 onwards. So therefore, what we find, these two models of the evolution and emergence of a state system have also contributed so far as this rise of constitutionalism and evolution of constitutionalism is concerned. Similarly, democracy has also evolved with gradual experiences, with many revolutionary upheavals and revolutionary ideas, and still it is evolving. In fact, there are different models of democracy as well, like we have different models of constitutionalism. Towards the end, in fact, we will also briefly touch upon this question of democracy. But what basically I am trying to discuss here, that this constitutionalism in modern times, with the unification of territories, particularly consolidation of national power, and therefore this quest for to have a mechanism to check this power of the state and the ruler, has basically contributed toward the rise of this constitutionalism. The third world model, as I was mentioning, that Asia, Africa, Latin America. Of course, African and Asian countries have altogether different experiences with constitutionalism. It is not that attempts have not been made to basically operationalize or to basically put them in practice, but the experience has always remained short-lived. The Latin American experience, because the evolution of a state, the nation state, and because of the revolution through, or one can say the revolt against the colonies, Spanish and other such colonies which were there in 1830s and 40s. Therefore, the formation of nation state has been different. Therefore, these experiences on this constitutionalism and democracy have also been different. So therefore, this third world constitutionalism, when we talk of, it is a very broad category, and therefore sometimes it appears highly unjustified that how one can club so many different experiences under this rubric called third world. But nonetheless, one can see a lot of commonality in this third world model of constitutionalism. One important factor which has contributed, or which has basically hindered the smooth functioning of a constitutional government, is basically a absence of a very effective, or one can say absence of a middle class in these countries, which has remained unstable. And this in fact is important, because this presence of a middle class or the elites, social elites, to basically deal with institutions, contributes in the stabilization of political institutions, to operationalize the ideas of constitutional government, is as important today as it was perhaps the time when Aristotle was writing and reflecting. We discussed in our last lecture that how Aristotle, when he talked of a middle path, the golden mean, and middle class as basically the mainstay of this type of system, he was basically highlighting precisely this aspect of constitutionalism and democracy. And this is what many scholars point out, that most of these third world countries have suffered on this account, along with many ethnic and other types of the divides in the society, because these societies are not homogeneous. But then to argue or to say that constitutionalism and democracy cannot succeed in a heterogeneous society or a plural society where multiple identities exist would also be not correct, because India offers the best example that how a country which is characterized by a lot of heterogeneity, a country which is plural in nature, where you have different linguistic groups, religious groups, ethnic groups, but nonetheless both constitutionalism and democracy have been doing wonderfully excellent job, and therefore that has basically created a kind of, put a poser before the scholars of constitutionalism and democracy, who at one point of time were arguing that constitutionalism and democracy both can succeed in only Western context, where the societies are homogeneous, where the nature of society in terms of literacy, poverty and so on and so forth is much conducive, congenial for the functioning of a constitutional government. But India offers a good posture that how it can succeed in a situation like India with lot of plurality and diversity. So therefore, just to argue that the third world countries, the major stress or strain on constitutionalism emanates from this source, that the society is basically plural, or there is a divided or one can say is heterogeneous, and therefore constitutional government has not succeeded and democratic experiences have not been very healthy, is off the mark. And therefore, how to understand this third world dilemma in terms of this democracy is another important issue before the scholars on constitutionalism and democracy both. Of course, institutional instability is there. Of course, the absence of middle class, powerful middle class in many of these countries is there. Of course, gradually it is evolving with the with the changes in economy, the changes in society. But another important factor which has also contributed is basically the kind of national movement which happened in these countries, particularly against colonial rulers. Because when the people were fighting, or certain groups were fighting, or the parties were fighting against the colonial rule, one predominant party emerged out of that process, and therefore that predominant party basically got control of the state system, and therefore what happened, that it monopolized the power. And therefore, in many of these countries we find that multi-party democracy was totally absent. There was no freedom of choice in terms of the political choice, because of absence of multi-party democracy. And therefore, when fighting imperialism or colonialism, these national elites played a progressive role. When it came to the question of democracy, when it came to the question of rule of law, when it came to the question of democratic rights of the people, they basically developed cold feet, and therefore they didn't transfer that power and authority which they had seized from the colonial rulers to the masses. Recently, what we have seen under this Arab Spring is precisely reflecting or showing such tendencies, that how this Arab nationalism, when they fought their colonial masters, they appeared very progressive, but when it came to democracy, they basically became highly reactionary and regressive, and therefore that generated a protest from the bottom, and people revolted against dictatorial rule of these nationalist elites, who at one point of time claimed to be very progressive. So therefore, from Arab Spring to many such experiences which we have seen in last in many decades in these Asian, African and Latin American countries, is basically testimony of this fact, that how this constitutionalism and democracy in third world countries has not been very smooth, and therefore one can say that rather it has been painful. Now India offers a deviant case, and therefore when it comes to the models, I have put Indian case not in the third world, but I have put it in the Commonwealth model of constitutionalism and democracy, along with Canada, Australia, New Zealand and so on and so forth, because of 2-3 reasons. Because of a relatively very stable democratic experience, not relatively, rather one can say very stable democratic experience, which is basically puzzling or intriguing even the scholars in social science, in political science, that how to explain the success of constitutionalism and democracy in India. This aspect we will take up later. On the other hand, there is combination of parliamentary and federal features, which is a hallmark of this Commonwealth model of constitutionalism, is also to be seen in India, along with Canada, Australia and so on and so forth. So therefore, India comes under the category of Commonwealth model. The socialist model, I have already mentioned that only 2 countries come to my mind. Of course, the many countries later claimed to be socialist, including Cuba, Nicaragua and many Eastern European countries. But 2 countries, if one takes as a model, erstwhile Soviet Union and China, and particularly the Soviet Constitution of 1936, particularly during Stalin's period, and subsequently in the post-Stalinist period 1977 Constitution. They try to draft constitution. They try to claim that socialist constitutionalism was different from the liberal constitutionalism. But what one finds that under the name of, or in the name of dictatorship of proletariat, in the name of Marxist Leninist theory of a party based government and rule, what socialist constitutionalism offered was basically a very distorted version of rule of law, political freedom, political choice, and so on and so forth. So therefore, instead of constitutionalism making way for a limited government, what we find that the socialist constitutionalism was characterized by absolutism or authoritarianism or absolutist government, a powerful government of one party, that is the Communist Party, because of a different theoretical justification which was given for such type of rule. But nonetheless, they claim to be a socialist, working with a socialist constitutionalism. And therefore, what I observed in the beginning, that in socialist countries what one found was a constitution but no constitutionalism. Unlike Britain, about which Thomas Paine had said that it was a constitutionalism but no constitution. Now, like Soviet Union, China also has gone for drafting, modifying its constitution from time to time, starting with 1954 of the Communist Revolution, then 1975, then 1982, and subsequently we find that many changes and modifications are made according to their economic changes, economic transformations. But the nature of a state power has remained same, one party rule, the rule of the Communist Party, absence of multi-party democracy, and therefore the kind of rule of law which is basically prevalent in these countries is much different from what we normally understand it in terms of a modern liberal democracy, particularly in terms of the political choices it offers, in terms of the institutional mechanisms it put in place, and in terms of the redressal of human or the people's grievances, and ensurement of, one can say, that the kind of entitlement which gives to its citizens in terms of democratic rights. In fact, these socialist experiences or socialist constitutionalism is totally different. So therefore, this socialist and the third world constitutionalism, we have seen that how they deviated from this both Anglo-Saxon and continental and Commonwealth countries, and therefore three of them can be broadly considered in terms of modern liberal democratic constitutionalism of modern times. So basically what we will do, that we will see one by one the Anglo-Saxon, the United States of America, Britain, and then continental Europe, particularly the Swiss model, and the Commonwealth countries, particularly Canada, Australia, and India, specifically India, that how they have evolved. These four models of constitutionalism, Anglo-Saxon, continental, Commonwealth, socialist, and third world, rather five models, give us a very good idea that how in modern times constitutionalism has evolved. but one should also remember that it is not, these models do not only tell about constitutionalism, but also tell about democracy. Because in fact, the moment we talk of constitutionalism, we are also duty bound to discuss democracy, because essentially the idea of constitutionalism has emerged out of human engagement with this concept of democracy, because the raw power of the people, which has a tendency to become majoritarian and result into mobocracy, this idea of constitutionalism has acquired salience and importance. So therefore, through these 5 models, one can also see the evolution of democracy. But right now we are concerned with this constitutionalism, and this third world and the socialist models we have discussed, that how they are totally different in terms of different experiences and different social basis of that constitutionalism from what normally we will discuss under liberal democratic constitutionalism of Anglo-Saxon, continental, the Commonwealth models. Now, to begin with, this Anglo-Saxon model, within Anglo-Saxon model, in fact, normally we talk of basically the British and the American experience. Now, the British constitutionalism, as it is to be remembered, is best characterized by 2-3 important features. One can say that British Parliament is considered the mother of Parliament. In fact, the concept of parliamentary sovereignty has emerged from the British experience. There are many institutional ideas. Many ideas about institutions, political institutions, we owe to the British history and British constitutional development. But nonetheless, we should remember a few things about Britain. Britain does not have written constitution, but it is basically functioning as smoothly, as effectively as any constitutional government in today's world based on written constitution. How it has been made possible is itself something interesting to observe and discuss. In fact, 2-3 important features of British constitutionalism is in fact rule of law. In fact, as Dicey, the British jurist, the legal constitutional expert, the way he theorized rule of law, equality before law, and basically also ensured absence of any kind of discretion and discretionary power. So therefore, rule of law is one of the bastion, or one can say the basis or the foundation of the British constitutionalism, along with the concept of parliamentary sovereignty, because parliament is sovereign. There is no concept of judicial review, which we will see later that how evolved United States of America. Of course, not part of a design, but by a constitutional accident, or one can say political accident. In 1803, when Marshall, the American Supreme Court judge, propounded this doctrine of judicial review in a very famous Marbury versus Madison case. But nonetheless, we can see that in Britain we don't have any judicial review. That means the will of the people through parliament and its representatives sitting in the parliament is sovereign. There is nothing beyond it. And therefore, as Ramsay Moore once said, that British parliament is so sovereign that it can do anything on this earth except turning a man into woman and woman into man. So Ramsay Moore was basically hinting at this absolute omnipotent source of omnipotent power of the British Parliament. And the third important characteristic is unwritten constitution. Constitution is not written, but then how it functions? It functions on basis of customary and common laws. It functions on basis of conventions. It functions on basis of certain traditions and practices. So therefore, political culture of British constitutionalism is altogether different from normally what we understand in case of United States of America. So therefore, Britain, which cradled many new ideas, modern ideas, including the democracy and constitutionalism, of course in a different way. As I mentioned earlier in my discussion, that how James I, when he invoked this idea of divine rights of king to rule, generated a lot of reaction, and social contract theory came as a result of that. And therefore, when Locke talked of limited government, and to some extent one can say even the separation of power, though of course it is associated with the ideas of Montesquieu, who called British system based on separation of power, but it was erroneous reading of the British system, because what he was meaning by separation of power was basically applicable to United States of America, not Britain. So therefore, what we find that Locke and Montesquieu's idea of separation of power, of course, is directly applicable to United States of America, but Locke's idea of limited government, one can say, which got crystallized and applied in different constitutionalism, of modern times. So Britain, therefore, what we find that is functioning on basis of unwritten constitution with the help of customary laws, common laws, with help of conventions, with help of certain practices, and so on and so forth, and therefore British constitutionalism is different. But the three important innovations of modern time in terms of constitutionalism cannot be seen in Britain. One is federalism, the second is of course judicial review, and the third is the Bill of Rights or fundamental rights. Though it is a different matter that it was never constitutionally sanctioned, it was never constitutionally granted, but nonetheless Britain had a kind of this rights of the people in a different format even before it made its appearance in United States of America. Here one is reminded of Magna Carta of 13th century, 1215 in England. In fact, this under Magna Carta certain rights were given to the barons and the free citizens. Then 1628, the Petition of Rights, and subsequently the Bill of Rights in 1688. So all these things gradually evolved into a full-fledged Bill of Rights as today we see in terms of American Constitution, and that how it was constitutionalized. They found place in the Constitution. Though one thing we should remember that even United States of America, the rights were not part of the constitutional design, rather they emerged out of the first 10 amendments. How they emerged, this is also something interesting which we will discuss in context of the American model of constitutionalism. So therefore, what we see that the British constitutionalism has contributed in terms of the concept of rule of law, parliamentary sovereignty, unwritten constitution, customary and common laws, but of course federalism and fundamental rights or the Bill of Rights. These two features, which are also considered modern in its nature and innovation, in fact are not to be seen in the British constitutional design or British constitutionalism. The next model after the British constitutionalism is the American model of constitutionalism, American system, which is again different from the British in terms of many things. First of all, we should remember one thing, that America is a case of a revolutionary model, in fact example of a revolutionary model, unlike Britain, which is the example of evolutionary model of constitutionalism. Things have evolved. Even the parliament, institution of parliament has evolved over the ages. Many practices have evolved. In fact, many conventions have evolved. So things have been evolving. There has never been a revolutionary rupture or break in the constitutional history of Britain. And therefore, in fact, Edmund Burke admired the British model and rather had reservation the French model, because Burke thought that this evolutionary constitutionalism is better suited from the point of view of people's rights and democracy. But nonetheless, when we come to the American model, what we find that American model is example of revolutionary break in history. It is example of a revolutionary model of constitutionalism. United States of America, as is well known, was a colony of Britain, and the 13 colonies revolted against the masters, and basically they waged war against the crown. And finally, after American War of Independence, when they attained independence, they assembled in a continental congress and created a confederation. Therefore, United States of America's evolution from confederation to federation is itself very interesting to observe. So therefore, initially they started as a confederation. Now under confederation, or this arrangement, states retained all powers, and the central, the federal government had highly limited power. In fact, what happened that the confederal government, or what one can say the government at the center, had limited power. But it didn't work properly, and therefore immediately United States of America made a transition from confederal to federal, and therefore what we find that another convention was called in 1787, that is known as Philadelphia Convention, where a federal constitution was drafted, and the constitution which has survived till now. Now these federalists who basically wanted to get rid of this confederal arrangement, basically this idea of federalist is best represented in terms of a book or a writing called the Federalist Paper. In fact, this paper, the author of this Federalist Paper, Alexander Hamilton, James Madison and John Jay, they produced it in the pseudonym Publius, and therefore in fact that gives us very good idea that how Federalists thought about constitutionalism, how Federalists thought about limited government, how Federalists thought about democracy and people's will, and therefore in fact this becomes the source to understand American constitutionalism. One thing is to be remembered, that they always suspected the raw power of the people, and therefore from the very beginning they wanted to checkmate power with power, and this is how they evolved the concept of separation of power. But not only separation of power which exists or happens at the horizontal level, the three institutions of the state, legislature, executive and judiciary, horizontally they are separate and they are integrated, and one checks the other. So the check and balance concept emerged out of this horizontal separation of power, which of course is traced to the idea of Montesquieu, but as I mentioned, that can be traced to the idea of Locke as well. So therefore this is one, that they suspected the raw power of the people. They basically thought that this could be the tyranny of the majority, it could result into mobocracy, and therefore they basically valued limited government. They wanted to checkmate all sorts of authority and authoritative power. So therefore this is something to be remembered about United States of America. Now of course, so far as this Federalist Paper, as I mentioned, is a basic document to understand the American system, but of course one thing is also to be remembered, that though it is a revolutionary model, but like Britain it has also evolved, and many new ideas have been added into this original design of 1787, and the two important things as I mentioned, one was of course the judicial review, which emerged later through a judicial pronouncement by Judge Marshall in Marbury versus Madison case in 1803, and the other addition one can see is in terms of Bill of Rights, because Bill of Rights was not part of the original document, rather in fact it came through first 10 amendments, unlike the British king giving Charter of Rights under Magna Carta or Bill of Rights and so on and so forth. Bill of Rights are integral part of American Constitution today. How this happened is also important to remember, because now they are well entrenched in the Constitution itself. And when this Bill of Rights came in the American Constitution through first 10 amendments, one thing is to be remembered, that it was largely on account of the debate between the Federalist and Anti-Federalist, because United States of America, after they revolted against the Crown, and when they assembled and they drafted the Constitution, Confederal Constitution, the debate was still going on between the two groups, the Federalist and the Anti-Federalist. The Anti-Federalists wanted to empower people. They wanted more instruments for direct participation of the people. But the Federalists had a strong reservation on this. They always valued representation. They always wanted to keep the power of the people under check through law, through procedures, through institutions. So therefore this resulted into a kind of debate between the Federalist and the Anti-Federalist. The Federalist lobby was best represented by Madison, whereas the Anti-Federalist lobby was best represented by Patrick O. Henry, who was a great anti-federal critic. In fact, rather he wanted a second convention when he discovered that people's rights were not entrenched into the constitution, and later on, largely on account of such hard-hitting critique or the protest, or one can say that resentment, that Madison tried to rectify it or assuage the hurt feelings of this anti-federalist through the first 10 amendments in the constitution, which came as a Bill of Rights. And later on, of course, Jefferson also agreed, and 1789 we find that the first 10 amendments to the constitution were made, because the federalist anti-federalist debate has contributed substantially in the enrichment of American constitutionalism and American democracy, because the federalist stressed on the limited government, on representation, whereas the anti-federalist stressed on republican values, on participation of the people, on instruments of direct democracy. Therefore, in fact, the anti-federalists were more for a populist democracy, the direct democracy, but the federalists were slightly more comfortable with the concept of representative democracy through institutional checks and balances. So therefore, in fact, we find that the federalist anti-federalist debate resulted into certain new innovations, particularly the Bill of Rights, because the federalist argument was very simple, because federalists like Madison, they thought that in United States of America there was no need for Bill of Rights because of the limited power of the national government, and therefore Bill of Rights is required in those countries where the ruler, the state, the central authority has immense power, and which can threaten the peoples and their life, particularly the way the crown can pose a threat to the people in Britain. But United States of America, there was no such threat of majority rule because of number of instruments which were devised, and therefore Bill of Rights was not required. But this argument was not bought by the anti-federalists, and therefore ultimately as a compromise one can say that first 10 amendments had to be brought, and the Bill of Rights got entrenched in the constitution. Now, along with this Bill of Rights, another important innovation which happened, and not as a constitutional design but accident, was judicial review, what is known as due process of law. And what we see that how in 1803 under the Marshall Doctrine, under the name of the Chief Justice Marshall, who gave this theory that how judiciary has to review the acts of parliament. But nonetheless, this judicial review is different from the way judicial review has evolved subsequently in some other Commonwealth countries, including India, where the judiciary does not only review the acts of parliament, but also also reviews constitutional amendment, because it is normally argued that under judicial review, judiciary cannot review the amendment, because that amending power should lie with the parliament, should lie with the people, and once it is amended, the judiciary has to interpret it. But India has gone certain notches ahead of this original concept of judicial review. That will take up when we will come to this Indian case of constitutionalism, Indian brand of constitutionalism, that is a Commonwealth model. Now therefore, the 5 features of American model: separation of power, checks and balances, federalism, Bill of Rights, and judicial review. These 5 things can be considered to be perhaps the foundation on which American constitutionalism stands. The separation of power, as I already mentioned, that how the 3 branches of government are separate and different, and then also how they are related to each other, that is checks and balances in terms of how one checks the other, like Senate, the judiciary, and the presidency, that is the executive, how 3 of them have a kind of powers which they share in many areas, in many respects, including appointment, execution of laws, and enforcement of rights, and so on and so forth. So this is one thing. So but this horizontal division or separation is accompanied by another division that is vertical. This is called federalism, that center in the states, the federal government and the states, they have division of power, their division of jurisdiction, and federalism is perhaps the innovation of the American minds. And therefore, in the evolution or the history of constitutionalism, one can say that federalism is the most original contribution of United States of America through this Federalist paper, Madison, Jefferson and Joe. And therefore, what we can say that separation of power can be traced to Locke and Montesquieu, but federalism can be traced to only these three important minds of modern period, along with Bill of Rights, which I said that comes through amendment, though as an idea or a concept is not new, but constitutionally entrenched idea. As a constitutionally entrenched idea, it is definitely totally American constitution. And finally, judicial review. So, this is the American system based on federal presidential system, not a parliamentary system like Britain. Now, when we talk of this Commonwealth model, basically we find this combination of certain things from American and certain British, and with certain new innovations like India, we can say, where you have combination of individual and group rights and so on and so forth, and therefore giving us a very good glimpse of how constitutionalism has been evolving even outside this Anglo-Saxon world, and some of these Commonwealth countries are perhaps the best example of this evolutionary pattern of constitutionalism. Now, coming to this Commonwealth model, as I mentioned that Canada, Australia, India, New Zealand, these are the examples of the Commonwealth model. But before I come to Commonwealth model, we should also remember the United States of America. There is another important feature, that is the second chamber, that Senate. The kind of role the Senate plays in federal polity is another important contribution which American constitutionalism can boast of. So therefore, that thing also should be kept in mind. Coming to this Commonwealth model, you have Canada, Australia, India, New Zealand, where you have a combination of both parliamentary and federal system. Why they have been combined is also something interesting to remember. But along with Commonwealth model, there is also a continental model, and under continental model we have the French, German, the Swiss and so on and so forth. The German, of course, has had a different history altogether, Weimar Republic and then subsequent experiences and so on and so forth. But in the post Second World War period, what we find as the German model is also generating lot of interest among scholars. The French, of course, a very important contribution in terms of the evolution of democracy after French Revolution, but then how that was superseded by authoritarianism of a kind of absolutist power of Napoleonic and Bonapartist type is perhaps another matter for discussion so far as the evolution of democracy is concerned. But nonetheless, the French system is also is a very good example of that how constitutionalism can be modeled and modified in context of different societies. So therefore, the French system, which is a kind of presidential system, but with lot of uniqueness and a lot of features which deviate from United States of America, is another interesting case to remember. But the Swiss model is perhaps the most interesting continental model. 1848 as a revolutionary constitution, it emerged out of civil war and revolution. In fact, 4 linguistic communities, German, French, Italian and Romance, they basically have federated as a Swiss federation. Of course, some cantons are Catholic and some cantons are Protestant, and what we find that in Switzerland the federal central government is called cantonal. There is a federal government, that is cantonal government, and there is a state government which is called cantonal government. The central government and cantonal government, this federation is based on 2, along with the third, that is a commune government, which is a local level government, and all of them share equal power and revenues. Of course, Swiss constitutionalism is interesting in terms of a very innovative idea of recall and and other mechanisms which have evolved for instituting direct democracy. Now, in fact, this initiative and recall, the two important features of Swiss constitution, are basically matter of interest for all experts and all observers of constitutionalism world over. So, therefore, this continental model also gives us a very good idea that how in continental Europe this constitutionalism has been evolving and basically making important contributions. So, among Commonwealth models, this Canada, Australia, India, New Zealand, Canada, Australia and India are very important because all three of them were British colonies. In fact, Canada and India, because what we find that Indian constitution, particularly Government of India Act 1935 was basically modeled on the Canadian Act of 1862. So, therefore, what we find that India's linkage with with Canada, of course through Britain, because what happened, that Britain had drafted both acts, the Government of India Act as well as the Canadian Act, and therefore what we find that certain features which we find in Indian constitutionalism are to be seen in Canada and in Australia. Particularly this combination of federal and parliamentary features. Of course, so far as judiciary is concerned, Indian judiciary perhaps is becoming more important, more powerful than perhaps the judiciary is in Canada, because still we find that in Canada it is highly reverential toward the parliamentary sovereignty. Even the Bill of Rights, in fact, emerged in Canada in 1982. But we find that in India it is part of the constitution. So, therefore, in fact, in spite of many similarities between the Canadian and Indian constitutional development, what we find that Indian constitutionalism is has gone ahead of its other Commonwealth counterparts in terms of combining individual and group rights, in terms of deepening of its federal engagement, in terms of ensuring minority rights under fundamental rights, in terms of many institutional evolutions which are happening in India. In fact, of course, there is one example of Belgium where you have a federation based on both on territorial institutions as well as identity based devolution of power as well as territorial territory based power. But in India, of course, it has not gone for that type of federal devolution on based of identities the way Belgium has done, but nonetheless the way India is combining individual and group rights through very elaborate affirmative action program, through number of constitutional instruments, and thereby deepening both federal experience as well as the parliamentary experience. In fact, India is becoming a very interesting case for the scholars of constitutionalism and democracy. The way constitutionalism has evolved, accordingly democracy has also been evolving through number of models. The elitist, pluralist, deliberative, number of models have emerged in recent times, along with certain other old direct and indirect democracy model which were prevalent earlier. So, therefore, what we find that both constitutionalism and democracy are evolving, particularly the way new challenges are emerging in human society, and therefore, the new reflections are also coming.
Dear friends, due to paucity of time, we have to stop a lecture here. On that note, we would like to thank Dr. Satish Kumar Jha for coming here and delivering this wonderful lecture. And thank you, dear friends, for watching our lecture. Stay tuned and keep watching. Thank you.